With the Supreme Court dismissing the application filed for the review of its judgment which sacked Ihedioha as governor of Imo State, lawyers at the court have given divergent opinions on the judgment and its antecedent consequences on the nation's judicial system. Ihedioha had asked the Apex Court to set aside its January 14, 2020 judgment that removed him from office, arguing that the judgment was obtained by fraud by the All Progressive Congress and its candidate, Hope Uzodinma. In a motion filed by his legal team headed by Kanu Agbabi, the former Speaker of House of Representatives said the appellant and respondent Uzodinma fraudulently misled this court into holding that a total of 213,495 votes were unlawfully excluded from the votes scored by the first appellant and respondent in the gubernatorial elections of March 9, 2019 in Imo State. The first appellant admitted on the cross-examination that he was the person and not the third respondent, INEC, or any of its officials who computed the result that gave him the 213,495 votes alleged to have been excluded from his total votes in the election. However, the majority judgment read by Justice Olukayode Ariwolo said the application for the reversal of the ruling lacked merit. Justice Ariwolo said, "It is settled law that this court has no power to change or alter its judgment or sit as an appellate court over its judgment. There is no doubt that the court has inherent power in respect of matters within its jurisdiction, but certainly has no inherent power to assume jurisdiction in respect of a matter not within its jurisdiction." While Uzodinma and his party, the APC, got a favourable judgment from 6 of the 7-man panel of justices who held that the judgment of the Apex Court cannot be reviewed, Justice Sentus Nweze, in his dissenting judgment, nullified the declaration of Uzodinma as governor on account of the wrong declaration. He also declared that a judgment or order of the Supreme Court can be set aside on merit and has done so in the past. Justice Nweze said the decision of the Supreme Court in the matter will continue to haunt our electoral jurisprudence for a long time to come.
The Supreme Court 6-1 dismissed the application on the ground that it lacked merit, that the Supreme Court does not have the jurisdiction to review its judgment or to set aside its judgment, unless on certain exceptional grounds, which none of those grounds was playing out in that case. However, one of the justices dissented. So as far as he is concerned, he found that the decision ought to have been set aside, and he set it aside. The implication of the decision is that he expressed his opinion, but then the majority carried the day. In other words, the authority for whatever it is now is the decision of the 6 justices that will now be the authority for subsequent application that will come. So if any other person brings any application similar to this, we rely on the decision just delivered today.
What they have now done is to give judicial backing to illegality, judicial backing to fraud. Somebody gathered fake results and packaged in the Ghana must go and brought to you. He said it was 388. In his evidence laid at the tribunal, he tendered 366. You computed it and gave him all the scores. Where was my own score? I was a candidate in that election. What the Supreme Court has done is to give judicial pronouncement to criminality, to electoral fraud.
I've studied law in New York, England, and Nigeria. And I have to tell you that the sanctity of the Constitution is invaluable anywhere in the world. So if my learned colleague is over there ranting, saying that the Supreme Court has murdered the democracy this time, is absolute fallacy. The decision was well thought out.